Hi, I'm Scott Hervey with Weintraub Tobin.
And I'm Josh Escobedo with Weintraub Tobin. Welcome to another edition of The Briefing by the IP Law Blog. Scott, we're here today to talk about short form copyright assignments. I understand that you wrote an article about this a while back, and I was actually looking at it the other day and I asked myself, why do we do this? The Copyright Act doesn't necessarily require the recordation of these documents, so what is their intended purpose?
Right, that's true. The Copyright Act does not require short form assignments or short form options to be recorded. The Act requires that if you're going to transfer an interest in a copyright, an exclusive interest or the whole copyright, that transfer has to be in writing, but it doesn't have to be recorded. So transfers and options, they're recorded in order to provide constructive notice of the transfer of ownership and to vest the new owner with the right to sue for infringement. Because you can't sue unless you have filed either your copyright application or filed whatever instrument it is that vests you with ownership of the copyright. But there's one other reason to record the transfer of copyright ownership, uh, and and that's to address conflicting transfers.
What does
So,
that mean, Scott?
yeah, so that's a good question. So some may assume that once the seller of a copyright interest transfers ownership, that the seller can't sell the same interest a second time. Well, let's deal with the hypothetical of a motion picture studio optioning a book for a motion picture. You're not going to think that the author is going to option its book a second time to another studio, but that may happen. If if that does, you have potentially conflicting transfers. You have the first option to the first motion picture studio, and then you have the later option to this later motion picture studio. And the one executed prevails first only if it's recorded in a manner required to give constructive notice under Section 205C. So it's got to be recorded within 1 month after its execution in the United States, or 2 months if it's executed outside of the United States, or at any time before recordation in such manner of the later transfer. So in other words, it's got to be recorded before the recording of the second transfer. If it's not recorded at any of those times, so in other words, if the second motion picture studio records their transfer first, and assuming that the second motion picture studio, they were a bona fide purchaser for value, they had no knowledge of the first transaction, they acted in good faith, then they would have superior rights. They would have the right in the copyrighted work, and the studio, the first studio, would have bubgus.
Would the first studio have any form of relief available to it?
Well, certainly it would have relief against the unscrupulous author, right? They would have a claim for breach of contract, and so maybe they would be able to recover their costs. So the option money that they paid the author, maybe attorney's fees if it's in the contract, but they wouldn't be able to recover lost profits. So they basically lost the whole economic value of entering into that transaction just because they failed to record a short form option agreement.
So let me just see if I understood that correctly, Scott. So if a first purchaser comes along, he gets his short form copyright assignment, he doesn't record it. A month later or 2 weeks later, a second purchaser comes along, assuming no knowledge of the first purchaser's acquisition of the copyright. They purchased it from the unscrupulous author. They then prudently record their interest. They would likely be deemed a bona fide purchaser, and the first studio would essentially be out of luck.
Right, right. That's correct. The second studio would have all the rights, and the second studio would have all the rights, and the first studio would be left holding the bag.
That seems like as good of a reason as any to record your interest.
It certainly is. I'm Scott Hervey.
And I'm Josh Escovedo.
Thanks for listening.
We hope you enjoyed this video on the briefing by the IP Law Blog. If you're interested in additional intellectual property content, subscribe to our YouTube channel. Thank you.